No, Jasmine doesn't.
Item 1, pronouncement of judgment.
We give the benefit of doubt to the appellant and he is acquitted. He is liable to be released forthwith if not required in any other case. We are inclined to impose a condition that the concerned jail authorities where the appellant is currently lodged shall obtain an undertaking from the appellant that he shall surrender before the authorities of the said jail if so required by virtue of any judicial order in appeal, if any, preferred against the judgment and order. Yeah. Put on record our appreciation towards your effort.
Item 2, to be spoken to.
Sentence hearing matter.
Hmm?
Sentence hearing
Hmm.
matter. Not yet. On the last occasion, I had given that judgment of Frederick.
No, in fact, there's now a note from the registry that the original records are not required by the Supreme Court. So that is a specific requisition was not to send. So that
Only scan copy was sent.
scan copy was required. None appears for the appellant. How Ms. S. Jahanlal APP is present. Next paragraph. Pursuant to order dated 29/1/2024, the registry has put up a note dated 2/2/2024 to bring on record that the Supreme Court of India had requisitioned scanned copies of the trial court records which have been sent and received by the registry of the Supreme Court of India. Accordingly, in light of the said note, the court is inclined to direct that the trial court records be sent back to the Court of Learned Sessions Judge Hojai. Post. The This order shall be read together with stop. Therefore, the registry is not required to comply with the order dated 29/1/2024 to send the trial court records to the Supreme Court of India in view of the specific requisition by the said court. Next, this order shall be read together with order dated 29/1/2024.
So they'll do the sentence hearing and send the records back. In fact, after item number 1, 2 was called and she was waiting to mention, I had stopped her because judgment was supposed to be delivered.
Yes, which item?
Sorry, Lordship. I on your A alone is out of station, Lordship.
Oh, in that,
Item-
acha. Mr. A. M. Alamgir, counsel for the appellant on behalf of Mr. A. Alam, counsel for the appellant on record. Mr. F. K. Ahmed also. K. Ahmed for respondent numbers 2 to 10. This, the order has to be modified. Original Supreme Court, original records are not required to be sent to Supreme Court. There's a requisition only to send scan copies.
May I read the lordship? Like to mention item number 7, lordship. And
7.
for the
Cause list.
respondent. Lordship, and for the respondent. I want to withdraw my name from the cause list, lordship, because I am no longer involved in this matter. And I am appearing on behalf of S. Muni. I'm going to withdraw his name from the cause list.
Oh, you can't do that. There's a
Registry
proper
noted,
procedure.
They have to approach the registry.
Merely by asking it won't happen. Correct. You file any application? No. You just can't withdraw. It's like a ball in the cricket, what you call, which is thrown by the bowler. Once it goes, it has to have a logical conclusion. Unless the umpire declares is no. Correct. There's a procedure, follow it. We'll just adjourn it on the, Mr. Dhar, any objection? No. Mr. A. Dhar, counsel for the learned amicus is present on the prayer made by Miss S.
And
N. Islam, counsel for the private respondent. The matter stands adjourned today. List after 2 weeks. Absence, sir. Yes, give it to the court master. They will have to make some adjustments. Three and 4 jail appeal under 383, read with 374(2). This is Boxer matter. The the registry shall, the appellant was convicted and sentenced to undergo rigorous imprisonment for 20 years for committing offense under Section 6 of the POCSO Act and to pay a fine with default stipulation. Therefore, the registry shall implead the respondent number 2. So the informant of the victim as respondent number 2. And thereafter the matter will be listed for passing appropriate orders. uh, Party, next para, pending impleading of the informant of the mother of the victim as respondent 2. The court is inclined to admit this appeal for hearing. Call for the LCR. Pending impleading of the informant of the mother of the victim as respondent 2, issue notice returnable on so and so date. After 6 weeks, the registry shall process a notice and provide the same to Mr. S.H. Baral and APP, who has entered appearance for the state for onward service on respondent on the newly implemented respondent 2 through the jurisdictional North Lakhimpur Police Station, officer in charge of North Lakhimpur Police Station. To the officer in charge of North Lakhimpur Police Station. First off, next one, the officer in charge of North Lakhimpur Police Station shall positively return the service report prior to the next date of listing. Next one, list on so and so.
20 March.
Where submit worship, your reminders queue has to be appointed to worship.
Oh, yes, yes, yes. Next one. As this is a jail appeal, the court is inclined to appoint.
Please look next present.
Hmm? Ms. B. Sharma Leonard, APP, as amicus curiae in the matter to represent the appellant. That also, that in the notice to be issued to respondent to, it shall be indicated that he may avail the he may apply before the Guwahati High Court Legal Aid Committee for appointment of a legal aid counsel to represent him, full stop. Her. Full stop. In the event she is unrepresented, the court reserves its right to appoint an legal aid counsel of the amicus curiae to represent the interest of respondent two. The just correct that language.
Item 4.
302. There was also another. The registry shall provide the required materials for the amicus curiae. This item number 4, appeal from jail 383 read with 374-2 CRPC. Appeal is this appeal preferred from the judgment and order of conviction dated so and so, thereby convicting the appellant for committing offense under section 302 IPC. And sentencing him to undergo rigorous imprisonment for life with fine of rupees 5,000 with default stipulation. Appeal is admitted for hearing, call for the records. The court is inclined to appoint. We appoint you, Mr. B. Prasad Leonard, APP as, Leonard Legal Aid Counsel as, sorry, Leonard Counsel as amicus curiae in the matter to represent the appellant. The registry shall provide relevant copies to the learned amicus curiae. Next, list after let a formal notice be issued without requiring the any steps to be taken, as Ms. S.H. Balan and APP has already entered appearance for the state. List after 4 weeks awaiting visit to LCR. Where is it?
Item 5.
Please roll this. This is an appeal against conviction registered under section 302, madam.
It has come for the first
Yes,
time?
yes.
Okay.
Maybe I remember.
Appeal under 374 CRPC by Mr. D. Bora, learned counsel for the appellant. By this appeal under section 374 CRPC, the appellant has asserted his conviction under section 302 IPC, and by which he was by judgment and order dated so and so, by which he was sentenced to undergo rigorous imprisonment for life and to pay a fine of rupees 10,000 with default stipulation, as well as he was convicted for committing offense under and he was also sentenced to undergo rigorous imprisonment for 2 years and to pay a fine of rupees 5,000 for commission of offense under section 498 capital A IPC. Default stipulation in respect of fine. Please admit it for hearing, call for the records. List out 4 weeks awaiting receipt of LCR. Let formal notice be issued on the state. This notice is accepted by Ms. S.H. Baral and APP for the state. Next para. List after 4 weeks. IA shall be considered on receipt of LCR. Here also issue notice to the state.
Item 6.
Yes, Mr. Yeah, it's come for the first time.
First.
We'll issue notice.
Conviction under
We'll issue notice.
Yes.
And bail will be considered on receipt of Nalcot records.
Only one typographical error, my lord, in the
Yes.
cost settle fees. Fine of rupees 5,000 is been written, my lord, it should be 15,000.
15,000.
Yes.
This. Okay. You have done correction on your behalf, but you'll have to put your signature. Ask as you need to put your signature. Sir, एक भैया senior एक भैया counsel for the appellant. Sin order of conviction. Notice record. You do that correction. And IA for bail after consideration. Here also issue notice.
In 389 petition, my lord, after, after.
Receipt of LCR.
Receive that, so that order will be.
Fast.
Deeply. Thank you.
Item 8.
Yes.
Appeal against the restriction of conjugal right. It was by the family court order. And then it delay. Delay of 84 days. But your lordship, not.
The explanation is not, was not satisfactory.
Figure 13 and 14 of the affidavit.
Mr. Bora, we are not satisfied with the explanation of delay. We are not inclined to issue notice. You see, earlier when the matter came, delay of 1400 something days.
As per
Whatever be 1400 days delay. Now, we were not satisfied and we permitted you to file an to have a better explanation. Now your explanation is that
the bill has taken
you
by
brief
the-
was taken away by her, by the appellant, from your chamber. And then she failed to return it to you.
you have due to for the.
No, whatever be the reason, but that can't be an explanation. You can't take advantage of your own fault.
No, no, I have nothing to say. I have explained as per her statement. She has filed an affidavit. Accordingly, I submit before your lordship.
No, no, you
For
can't
your
take advantage of
consideration.
that. And you were hospitalized, you have given your certificate saying that you were hospitalized for 3 days. 3 days we can understand, maybe 3 days, we'll take it 1 month. She came, went away, again came, say 1 month, let us say 1 month. But that doesn't explain 1400 days delay. We are not inclined to issue notice even.
Delay, I have explained from, I have explained on 13, paragraph 13.
We have read that you,
Yes.
when you are putting to you that statement, you must understand that we have read it. Anything I have left out? Did I leave out anything? When I
He
gave you
had
this,
taken away, so I could not take still. And definitely she, so I had, call him and take, return the bill. Accordingly, I took
no,
step.
you see, Mr. Pora, please don't identify with your client. You see, a lawyer will work when you are given instructions. If they have taken away the brief, you have no instructions, so don't bring you between. You see, we understand that the lawyer's duty will start when? When you have a brief.
Yes,
Can you show me a name of a lawyer who starts working in a brief without files?
definitely not.
Not. So why do you bring your name inside?
So thereafter, when the bill was returned, then took step. But in the meantime, what was the happened, the particular lawyer part, I have explained. Then your satisfaction is your lordship. I have nothing to say.
There's no explanation at all. There's no point sending it and returning it back. Issuance of notice also, you are not inclined.
It's my submission before your lordship. The matter is simply called restitution of conjugal right. That was allowed by the family court. But my contention, the appellant contention is that before deciding, he ought to have heard the appellant. The sole intention of the respondent is to avoid the alimony. He is going to file a divorce petition.
LK Boral and counsel for the applicant. Issue notice on this application filed under Section 5 of the Limitation Act, whereby the applicant has paid for continuing the delay of 165 days beyond the period of limitation in filing the connected appeal. The applicant shall take steps within 2 days for service of notice on the respondent by registered post with AD. The notice is made returnable on so and so. List on so and so. Date the- What is the ground of delay?
I mean, the leave application is listed before the delay application actually. Delay
I
application
think-
is 68 days delay. 68 days,
68 days.
and the respondent appears. I've given my reasons in paragraph 12.
It was आइए
I is the third file. I is there, I've seen the third file. I've given the reasons in paragraph 12. The judgment was passed in, was passed on 14/10/22.
Okay.
And then on 17th of November, Public Prosecutor Special PP wrote to DC Morigaon.
Okay.
Then on 27th/11, SP wrote to the DGP. Lordship knows the process that they undergo. And then on 26/12, SP had applied for the certified copies and had given it to the IGP. And then again, IGP wrote to the Principal Secretary on 27/12, the next day. Thereafter, they received the certified copy on 22/12.
You don't have an empowered person in your office. Home Department does not have an empowered person.
No, no, this is what it seems. They go from table to table and then. And then
just-
finally,
Your department just has to hire this Nehru Stadium. Put up 120 tables. Take 3 or 4 years time to do
It's a
everything in the table.
what has happened? They had taken actually.
You'll have an
3-4
added
months.
advantage. Sports days, there will be no office. There will be cricket, there will be.
They'll be doing these
Uh,
jobs.
So you don't have to work.
In fact, there are 3-4 months delay here. And Joint Secretary finally wrote on 6th of February and it reached the PP's office. And then it was filed. 68 days delay, the respondent side is here. Merit, I have a case.
Yes, Mr. Tewan, we condone the delay.
Oh,
You don't have a copy.
in fact, yes, service, as far as I is concerned, service seems to have not been completed.
Propolis, you made.
But since he is appearing.
You
he
give a
can
copy,
appear.
okay. List after a week. Yes, as Jahan London APP shall provide a copy of this interlocutory application. Because A, Diwar Learned Council for the respondent number 2. List after a week. For objection, if any.
As far as leave, that is served upon you, leave application.
No, first condemnation.
condemnation.
Leave application is,
Yes, that was the procedure, in fact, but with all my humbleness, few courts take up leave first. So that is how it has come. Lordship, I'll serve him the copy thereafter leave.
well, we have to take another proceeding to see whether that can be, limitation can be flouted, overridden by a judicial order.
I think leave, I think the condonation has to be first allowed. Thereafter, whether we can proceed as far as the merit of the case,
So what do you
Perhaps my
think?
sir can also-
We are doing what you are thinking.
Yes.
You notice something in his tone?
No second thought.
This will be an IA. Leave petition, you say, the leave petition will be taken up after disposal of IA so and so, Limitation Act or that. Okay, after a week.
Item 10.
Then I think the list is not complete. I couldn't see the file.
10 is Met appeal.
Oh, 10?
Hmm.
Not as per office note dated 31/2024 lodging. Mediation need further time lodging.
Okay. Your name?
J Ghosh.
Ms. J. Ghosh, Land Counsel for the appellant. Seen the report dated 25/1/2024 by the Guwahati High Court Mediation Center seeking further extension of time till 12/3/2024 to complete the mediation process. Full stop. Accordingly, matters stands adjourned today, granting extension of time till 12/3/2024 to make an endeavor to complete the mediation process. List on. List on 22/3/2024. Awaiting report from the Guwahati High Court Mediation Center. Okay.
Okay.
আপনি টেক ওভার করে বলেন।
Item 11.
11, the condemnation application is again there and I will take steps. There I have not, I think the order is also not there. Leave application, again, it has come up first, but I 473, I'll take steps.
Jahan AVP. Just seen the office note dated 13/10/2023. And this will be an IA criminal 473. As Jahan APP, press for has granted time to take granted 2 days time to take steps for service of notice on the respondent to the officer in charge of the jurisdictional police station. Notice is made returnable on 23/2024. The officer in charge of the concerned police station shall ensure that the service report is returned prior to the next date of listing. List on 23/2024. Then in criminal LP, you say this leave petition shall be considered on disposal of IA criminal 473 of 2023.
Item 12.
Paper book is ready here.
There's no
Happening.
representation from the amicus curiae.
Sangeeta Khattunia comes, he appears on a regular basis, but
How Miss SH, Miss S. Jahan and APP is present. Next, as the paper book is prepared, list the matter for hearing
of course.
in its turn.
Item 13.
Here also paper book is ready. And both side appears.
Your name?
Jay Hatimuria. Jay Hatimuria.
J.
Hatimuria.
Hatimuria, and counsel for the appellant, Miss S. Jahanlal APP, and Mr. S.H. Sikdar, counsel for respondent number 2 is present. As paper book is ready, list the matter for hearing in its turn. Appellants.
Item 14.
Which is matter of life matter. Probably matter, the objection for the prosecution is very
Yes, you file your objection.
No, Lordship, because we have not received the copy of the IA that is required.
You have not received. Pardon me?
They take step from 1 to 2024.
In I, there's no office note.
First back. Compare 1 to 24.
Supplementary file. No, 678.
If that be so, madam, we'll solve a copy today, madam.
Just one.
Fine.
How many respondents are there? Only one. So why did you ask us to see the records? Office note, why is it required?
As IL, I have not received the copy of the IL.
Oh, that's okay. We took, but why you are referring to this unnecessary exercise? He's ready to give you a copy. So why should we? Why you made us look at the order sheet and note sheets? Mr. P.K. Munir, London Counsel for the applicant, shall provide a copy of the IA to Ms. S. Jahanlal APP and Mr. N.J. Gogoi, London Counsel for respondent number 2. In course of the day, list after how much time for objection?
2 weeks time.
List after list, give a date after 2 weeks.
3 weeks.
List on so and so. for objection, if any, by the respondents. Oh, acha, I made the mistake of Mr. Jahan in the earlier case. Huh?
SH Bora.
Oh, in this case, I have wrongly recalled. Okay. SH Bora.
28.
22.
I'm growing old faster.
Item 15.
Okay, in this case, the appellant clause is convicted under section 4 of POCSO Act. Okay. Appellant convicted under section 4 of POCSO Act. Okay. I have verified the original document dated 25/1. Okay. As which is awaited.
So it's awaited.
State of-
This is POCSO. So we'll send it through the APP, otherwise it will be delayed again. Please file a written notices.
Objection we have filed, but we
But
will take.
notice has to be issued. Otherwise, if you don't take steps, there will be more delay. But Mr. Ayush Chaudhary, counsel for the applicant, and Mr. Jahan and APP for the state. As per the office note dated 25/1/2024, service report on respondent number 2 is awaited. So accordingly, the applicant shall take steps for service of notice on respondent number 2 by filing a return of notices and a copy of the memo of appeal and this connected IA to the registry, post of the registry shall process the same and hand it over to the learned APP for service of respondent number 2 through the jurisdictional, which police station? Morigaon. Saigon, okay, to the jurisdictional Saigon police station. Most of the officer in charge of Saigon police station shall ensure that the service report is returned prior to the next date of listing.
Item 16.
This is also a POCSO matter sentenced under section 6. Check the office note whether the service is done. It was.
You have not taken steps, Mr. Mahmood?
It appears that I have taken steps.
No, it's not here. Mr. M.U. Mahmood and counsel for the applicant shall,
But it appears that we have taken steps.
no, it's not here. At least the section does not have it. Shall take fresh steps for service of notice on respondent number 2.
15 to 23 seconds.
15 to 20, it's not here. It's not here.
And then that will go to Lanet 50 value.
Yes.
To police station, otherwise it is difficult to sell. Or
No, but you have to take steps first. Without steps, they can't be, notice can't be sent.
Don't know.
No, it's not here.
Even then, we will take
Huh.
a step, but it should be.
We'll put that.
To police station, well, otherwise.
Steps introduced for service of notice on the respondent number 2. So the registry after processing the notice shall hand it over to the learned APP and to Mr. S. Jahan learned APP for service on the respondent number 2 through the jurisdictional, which police station?
Bagri Bari.
Huh?
Bagri
Bagriwari Police Station. Just, the same officer in charge to return. Notice 23,
20 of March.
23, 2024.
Item 17.
You're there? Mr. Orlaskar, counsel for the applicant. And Ms. S. Jahan and APP for the state. Issue notice on this application, filed under Section 5 of the Limitation Act. For condoning the delay of 45 days beyond the period of limitation in filing the connected appeal against acquittal. The applicant shall take steps within 2 days for service of notice on the respondent numbers 1 to 9. So, formal notice, formal steps is not required to be taken on the respondent number 10. As the state has entered appearance through Ms. S. Jahan and the APP. However, a copy of this application be provided to her in course of the day. Notice is made returned on 23/2024, based on the said date.
Item 18.
Yeah, please, your lordship. Lordship, I'm for the applicant, why your lordship? This I has been filed for condemnation of delay for 35 days, your lordship. The grounds is stated in paragraph number 2, your lordship.
Okay, your name?
P. Demadi, your lordship.
Mr. P. Daimari, counsel for the applicant. Issue notice on this application under Section 5 of the Limitation Act for condoning the delay of 35 days beyond the period of limitation in filing the connected appeal. Steps into this. Notice is made returned on 23/22, list accordingly.
Much obliged, your lordship.
For hearing, item 19 to 31.
Today I'm here because of this matter. In fact, since 3 days I have been having running temperature.
So I hope I will finish today. 3, 4, 5 appeals. All will be covered, no, except one may have to take some. Some of the issue of education. Well, on the last occasion, I submitted before your lordship that in order to prove that the accused.
You were last at page 72, recovery memo.
Yes, yes.
You were in compilation 1.
I'm just trying to recap.
Yes.
So the prosecution has tried to, prove that the appellant is a member of UNLF with a terrorist organization by producing two kind of evidence. One is emails and the other is PW 9, 17 and 39. Now, I was on emails and emails I placed before your lordship first the disclosure memo, which is exhibit 111 at page 69A of the compilation 1. And for here I should see your lordship that as per the alleged disclosure made by the accused number 18, he was using two emails. One is greenplate09@gmail.com and the other was greenfield006@yahoo.co.uk. So out of these two, they could open only one, that is greenplate09. And then I placed recovery memo dated 18/11 at page 7, where below it was revealed that printout of the email sent, received, and available in the draft were taken from email ID greenplate009. And the same recovery continued on the next day, that is 19/11. That was exhibit 113 at page 72. This was the last recovery memo that I have submitted before lordship, based on the last of the. Now, these emails which were allegedly recovered have been proved by PW 59, because 53, I'm sorry, 53, Satish Chand. Paper book 3, compilation 3. 59. Replacing. Lordship got it at page 59.
Police station is interesting, after the name. Police station is museum.
Yes, yes. I'm a science graduate in physics with postgraduate diploma. These have not been necessary. I'll place second para. On 18/11/2010 at 4:30 PM, one person, namely so-and-so, he's accused number 18, was brought to my technical room by Sri S.P. Pani. I was discussing with accused number 18 in the presence of the witness. He voluntarily told me that he has been working in UNLF since 1982. And he is using two emails accounts, namely Greenplate and Greenfield, for sending, receiving emails in connection with the activities of UNLF. He also told me that if I provide him computer with internet connection, he can open the email account and show the email thereon to the IO. I took accused number 18 to the adjoining room with independent witnesses and IO. There I switched on a desktop computer having internet connection. I put my user ID and secure password and opened the computer. Then I handed over the computer to accused number 18. He started Internet Internet Explorer, so and so. Then your lordship will come to email account greenfield.com, open the printout of all the emails, so and so, were printed by accused number 18 through a laser printer attached to the computer. Then he says what are the exhibit that he has exhibited. 111 is a disclosure memo I've already placed. 112 is also is the recovery memo. And then 19-1 Melot, I have already placed this. The lordship will come to page 61. And I'll just show the relevant one line only from here. Melot, third paragraph at page 61. So we are concerned only with this. Exhibit 115.
What paragraph is 114?
114 is the certificate. I'll place it separately, that's why I'm not referring it.
The next page.
Below that, 114 is 115. 114 is a certificate purportedly issued under section 65(4) of the evidence. Now, my purpose of showing this to your lordship is that exhibit 115, which is the relevant exhibit, on the basis of this 115 series, they are trying to show that we are member of, the accused is member of, the appellant is member of UN. This is 115. There are no other evidence, other emails. And this email is exhibited by PW53, my lord, Satish Chand. Is only for that purpose. So he has exhibited. Now I'll take your lordships to the certificate. Before that, if your lordship permits me, I'll submit that the only way to prove an email, which is a computer printout, is by way of supporting it with a certificate issued under 65(4), 65(b)(4) of the Evidence Act. It cannot be proved through oral evidence. And if your lordship remember, the parliament case, Navjot Sandhu, which is reported in 2005-11, was overruled. Because in Navjot it was held that even if certificate is not there, it can be proved by the evidence, by the witness who knows about it, or who is like Satish Chandra here. Now that has been overruled in P.K. Bashir's case. I'll straightway come to that portion because I will be referring again.
Because there it was said that when he gave a, he got trapped because he couldn't control his mouth. He told in a, what you call, in a TV show that he had given a blow and the person died. Navjot Singh Sidhu. And
No,
that
no,
was
no,
taken.
Not that Sidhu. This is parliament, it's alliance, something is there. That is different case, where he is also wanted for legal.
So there also that evidence was accepted and he was retried. And
Yes. That was because that was a sort of extrajudicial confession. So, and he also made the same statement. That was, I mean, he didn't deny it. He wanted to bring it under section, I think, 304E, not amount.
no, but after he was acquitted,
Yes.
then he gave that statement and he was again,
Actually, there was review.
this review occasion because of that, his TV statement.
Because-
In TV program, he admitted that he gave that blow and the person died. So because of that review and then,
That's the portion I don't know. All that I know that he was acquitted by a bench comprising of Justice Chalmeshwar and Justice Paul. And after that, after Chalmeshwar had called, Chalmeshwar was not in favor of convicting him. It will appear from there. Then in a review for Supreme Court.
no review, that the basis of review was that TV show.
But the it's an extrajudicial confession. An extrajudicial confession before Stephen, not in presence of police. So maybe because of that, but that is not an issue here. Here, Navjot Sadhu, which I'm saying, I'll give your lordship. Your lordship will see first the page 54 of the compilation one. I'll straightway take the lordship. Sadhu's case. He is some Afzal and I not Afzal.
Compilation one.
Compilation one at page 54 is my lord. Compilation two. Yes. Page 54. This Navjot Sandhu is a parliamentary activist.
Oh, acha. Navjot Sandhu.
Page 66, if you lordship can come to.
Page 66.
The relevant portion of Sandhu's judgment is quoted in paragraph 21 of this Bashir's case. That paragraph 150 of Sadhu's case is quoted here. I'm placing that quoted portion. Navjot Sandhu is Afsan Guru, realize. I'm placing 100 and paragraph 150, which has been quoted. According to section 63, secondary evidence means and includes, among other things, copies made from the original by mechanical process, which in themselves ensure the accuracy of the copy and the copies compared with such copies. Section 65 enables secondary evidence of the content document to be adduced if the original is of such nature as it is not easily movable. But it's like computers. As our set of computers, it is the evidence is there that cannot be brought before the court. So in order to facilitate, you can take the printout and along with the certificate, it can be produced as secondary evidence. So 65 enables secondary evidence.
Just tell us one more thing.
Yes.
This, supposing there's a printout taken from a computer, this emails.
Yes.
There's a trail email, you understand?
Yes, yes.
There's one and then the
Yes.
trail goes on.
Yes.
So this certificate is to be appended to only one or it should be given to every letter?
Everyone, if it is produced as this 2 documents or 3 documents, it is produced as 1 document. Then it has-
Because if it is a trail, it is produced as one document.
if it is produced as 1 document, then 1 certificate will be issued.
Okay.
Now, your lordship will see this, section 65 enables secondary evidence of the contents of a document to be adduced if the original is of such nature as not to be easily movable. It is not in dispute that information contained in call record is stored in a huge server which cannot easily be moved and produced in the court. That is what the High Court has observed at paragraph 276. Hence, printout taken from the computer server by mechanical process and certified by a responsible officer of the service providing company can be led in evidence through a witness who can identify the signature of certifying officer or otherwise speak of the facts based on his personal knowledge. Irrespective of the compliance of requirement of section 65B, which is the provision dealing with the admissibility of the electronic record, your lordship will mark it, there is no bar to adducing secondary evidence under the other provision of the Evidence Act, namely 63 and 65. It may be that certificate containing the detail in subsection 4 of section 65B is not filed in the instant case, But that doesn't mean that secondary evidence cannot be given if the law permits such evidence to be given in circumstances mentioned in relevant provision, namely 63 and 65. Quote, close. It may be that it was a case where responsible officer has duly certified the document at the time of production itself. The signature in the certificate were also identified. This apparently in compliance with the procedure under 65B of the Evidence Act. However, it was held that irrespective of the compliance of the requirement of 65B, which is a special provision dealing with the admissibility of the electronic record, there is no bar in addition secondary evidence under section 63 and 65 of electronic record. Next one. The evidence relating to electronic record as noted here and above, being a special provision, the general law on the secondary evidence under section 63 read with 65 of the Evidence Act shall yield to them. Then, of course, general those convention, special law will always prevail over general law. It appears the court omitted to take note of section 59, which I placed before your lordship, and 65A dealing with the admissibility of the electronic record. Section 63 and 65 have no applicability in the case of secondary evidence by way of electronic record. The same is wholly governed by section 65A and 65B. To that extent, the statement on law on the admissibility of the secondary evidence pertaining to electronic record as stated by this court in Navju Tandukways does not lay down the correct legal position. It requires to be overruled, which we do. Now, this was followed in the next case, Arjun Pandit. The judgment is by Justice Rohington Naringal. Your lordship will kindly turn to page 113 of the same. 113. Just see the highlight. I'm not giving the reference because I have given him also the copy. Now, two paragraphs at page 114, I have already, my lord, annexed the relevant paragraphs. Page 114.
Yes.
I'm reading 61 first. We may reiterate, therefore, that the certificate required under 65B4 is a condition precedent to the admissibility of the evidence by way of electronic records, as correctly held in Anwar PV, which are just placed with your lordship, and incorrectly clarified in Safi Muhammad. Oral evidence in place of such certificate cannot possibly suffice, as section 65B4 is a mandatory requirement of law. Indeed, the hollow principle of Taylor versus Taylor, which has been followed in a number of judgments of this court, can also be applied. Section 65B4 of the Evidence Act clearly states that secondary evidence is admissible only if led in the manner stated and not otherwise. To hold otherwise would render section 65B4 occurs. 62, I'm reading now. In view of above, the decision in Madras High Court in K. Ramajayam, which states that evidence aliundi is alternative way, can be given through a person who was in charge of a computer device in place of requisite certificate under section 65B4 of the Evidence Act, is also an incorrect statement of law and is accordingly overruled. So these are on 3 judges of bench. Now I'll take your lordships through. Therefore, in view of these two pronouncement of judgment by the Supreme Court, PW 53 saying that I have taken out and I have exhibited it, that is not proof. That is not proof. That will not be taken as a proof. There must be certificate. And there is a certificate which I'll place before your lordship. Now, the certificate is, my lord, is exhibit 114, which your lordship will get at page 74 of compilation 1.
Where is that email? Email you said you don't have. Last time you,
So some of them it's the recorded, it's that the 115 is not there. After I place this certificate, I will take your lordship to specific emails which have been used again. But otherwise, there are many emails. We don't know what it is, what it contains. That we don't know. So first I will place this certificate and my submission will be all these emails are inadmissible. Lordship, come to page 74. I, Satish Chand, DSP NIA, IT NIA. I'm in charge of Satish Chand is PW 53, whose evidence I read. I'm in charge of Information Technology Wing of NIA, headquartered at Splendor Forum, New Delhi. I hereby certify that the computer installed at NIA office in New Delhi, from where data retrieved from emails on the disclosure of the accused, April 18th, in police custody is under my technical control and supervision. I further certify that the process of downloading of the above email was uninterrupted. There is not even a whisper regarding printout. One important thing you will also kindly notice it here. Kindly see the date of this certificate.
yes,
The lordship sees the date,
18/11/2011.
2011. And now kindly come to 70, same volume, page 70.
Recovery memo.
Recovery was made on 18/11/2010. This was after 1 year. The certificate is issued.
Typing error. Appears to be a typing error. Or you must have a sharp memory like you to recollect after a year.
But whatever may be, what the point I'm raising, perhaps that may not be very relevant. Now, your lordship has seen the certificate. There is not even whisper, I'm repeating it, not even whisper about printout. Computer printout is an electronic record, I don't have to Your Lord. But it is, I will praise the judgment. Now, what it says, it describes that so-and-so, a computer is installed in NIA office at so-and-so place, which is under technical supervision. And downloading was on interrupted. Besides that, it doesn't say what. Now, whether this certificate can be said to have certifying the secondary evidence that the printout they are taken before me. In my humble submission, there is not even a whisper of. Now, what should be the contents of 65 4B? It's given in that provision only which I have read before, Lordship, but not read it again. So it has been held in Bashir's case. What should be the contents? And I'll place that case again. Bashir's case, Your Lordship, is held at page 54 volume compilation. Volume बोल रहा है तुम.
Fifty-four of compilation.
I'll ballot place.
I was just recollecting, I was just sharing between my brother. But perhaps, to my knowledge, there may be more people, but to my knowledge, first lawyer to have computer in this court was K.P. Pathak, senior counsel, then B.D. Das. And then third, I was the third one. There might have been others, but to my knowledge, this.
My lord, I'll be referring four small paragraphs. 14, 15, 16, and 18.
And now the malady is that I don't know anything about computers. I took a course in COBOL, Commercial Basic Language. That was in 83. I had spare time after my metric exams, and I did that course. And it's hard to believe that I don't know anything about computers. Now you have to wait till the child is 18 months, give a mobile to them, and they will operate everything. There's a baby, my relation, I think is almost 20 months now. Baby knows the difference between the two YouTube symbols. It'll take out the relevant one and not the other one. It'll open it and then look at the YouTube, find out the cartoons and then look at the YouTube, and nearing 20 months. That is the age of the child. From the mobile apps, it'll locate which one is the concerned app, open it, and then baby is happy.
He taught me paid Paytm. They even have so many times I tried, but I cannot make it. He does it. He does all I don't know, I mean, I know, wish also to learn. I'm telling you. I don't want to remember. Now, well, can we come to page 64 of compilation 2?
64 compilation two.
This is parts of PV Anwar versus PK Bashir case. I placed section, I placed paragraph 21 where auxiliary new was put. I'm taking this 14, 15, 16, and 18. Page 64 is paragraph 14. Any documentary evidence,
64.
page 64, paragraph 14. Any
Yes.
documentary evidence by way of an electronic computer under the Evidence Act in view of section 59 and 65A can be used only in accordance with the procedure prescribed under section 65. Section 65B deals with the admissibility of electronic record. The purpose of these provisions is to sanctify the secondary evidence in electronic form generated by a computer. It may be noted that section starts with a norm abstentive clause. Thus, notwithstanding anything contained in the Evidence Act, any information contained in an electronic record which is printed on paper, stored, recorded, or copied in optical or magnetic media used by a computer shall be deemed to be a document only if the condition mentioned in subsection 2 are satisfied, without further proof of production of the original. The very admissibility of such documents as an electronic record, which is called as computer output, depends on the satisfaction of 4 conditions under section 65B2. Following are the specified conditions under 65B2, the Evidence Act. 1. The electronic record containing the information should have been produced by the computer during the period over which the same was regularly used to store or process information for the purpose of any activity regularly carried on over that period by the person having lawful control over the use of that computer. This is 1. 2. The information of the kind contained in an electronic record or of kind from which the information is derived was regularly fed into computer in the ordinary course of the said activity. During the material part of the said period, the computer was operating properly, and that even if it was not operating properly for some time, the break or the breaks had not affected either the record or the accuracy of its content. The information contained in the record should be reproduced. It should be a reproduction or derivation from the information fed into computer in the ordinary course of activity. Under section 65B4 of the Evidence Act, if it is desired to give a statement in the proceeding pertaining to an electronic record, it is permissible provided the following conditions are satisfied, as these conditions are of 65B4. 1. There must be certificate which identifies the electronic record containing in the statement. This is not there in that. Just say it is a computer in NIA office. There may be 100 of computers, there may be 5, 6 computers, we don't know. So there is no identification. Second, the certificate must describe the manner in which electronic record was produced. This is also not there. Certificate must furnish the particulars of the device involved in the production of that record. Is also not there. Particulars. The certificate must deal with applicable conditions mentioned in 65B2 of the Evidence Act.
No, but this would mean para 64B4A. There must be a certificate which identifies the electronic record, not the computer. So if this is the printout,
So it
that-
has to be.
this has to be not the computer.
The computer is below, my lord. My lord, here it is, I think your lordship is correct. Yes, electronic device was.
Because in the pre-page we are reading paragraph 14. Paragraph 14 says any documented evidence by way of an electronic record. So document by way of electronic record,
Actually,
So-
C perhaps. is-
C. A particular device, right?
Therefore,
Correct.
That has to be stated, plus what are the electronic records that are being produced is also to be stated. Because your lordship has seen one, there must be certificate identifies the electronic record. Here, the electronic record is computer printout, that is email.
No, but is this C, just I'm trying to understand
Yes.
your argument.
Yes.
Let us see that there is a computer here.
Yes.
In your
That's right.
front, there's a
Yes.
on the screen. Now, how do you identify this document? By giving the serial numbers?
Serial number should be sufficient, or IP number, every computer has its own IP number, isn't it?
No, IP is the internet
Document-
address.
doc- yes.
Internet address, not this.
Computer has the description of the computer.
Because I can only say the computer in my table.
But suppose there are 4 computers in your office. There are 4 computers. So identification will have to be different of all 4 computers. Numbers will be different. So that is the meaning. Because they have taken the printout from what was stored, what was said, and what was in the draft. So all these. Therefore, my submission would be one-line submission. The certificate is not in accordance with section 65B. Yeah. Now so from here I'm making this submission.
Hmm.
Because I'm told, if they have taken it, suppose the file, send file, there will be a separate numbering will be that this folder, send folder, taken out this much. And this is received from receipt folder. This was received and these are the emails that which have been taken. And then these are in the junk. Then only identification proper will be there. Here your lordship will find there is not even, they have not mentioned anything about printout. Printing, they had not, they're totally silent. Now I will place section 16, paragraph 16, my lord. It is further clarified that person needs only to state in the certificate that the same is best of his, to his knowledge and belief. Most important, this is important for me, most important, such a certificate must accompany electronic records like computer printout. So computer printout is an electronic record. Emails are electronic record. There cannot be any dispute. And then, my lord, it's an admitted position that there is nothing in the certificate which certifies that these emails were printed out from the particular device. Computer printout, compact disc, video compact disc, pen drive, etc., pertaining to which a statement is sought to be given in evidence. When the same is produced in evidence, all these safeguards are taken to ensure the source and authenticity, which are two hallmarks of pertaining to electronic records, ought to be used as evidence. Electronic records being more susceptible to tempering, alteration, transposition, excision, etc. Without such safeguard, the whole trial based on proof of electronic records can lead to travesty of justice. Then I'll place 18, my lord. The Evidence Act does not complete or permit the proof of an electronic record by oral evidence if the requirement under Section 65 of the Evidence Act are not complied with as the law stands in India. My humble submission would be, my lord,
If we say email, email would mean inbox and outbox.
Yes.
But it's a part of, let us say if I'm using Gmail, then we say it's a printout of Gmail. Even if I don't identify it to be from inbox or outbox, does it make a difference? Because that is a merely internal bifurcation of the.
but in any case, is there anything on the certificate from where anybody can see that yes, these printouts, exhibit 15 series, have been certified?
Just come back to that exhibit, page
74.
74. Compilation 1. Certificate computer data retrieved from emails on disclosure. Oh, acha. You say that the particular document is not identified.
No, emails have printout have been taken out. What will be identified? What is being produced in the court? The emails, printout. Printout is being proved in the court. It's not there. The process of downloading is a different thing. He only said these computers are within my technical control and process of downloading them uninterrupted. This is what he said.
Take a break and come back. But we have a very confident smile from Mr. Das.
He's always confident. He's always confident. Vice Chairperson. Well, the two grounds on which I will urge your option to hold that these emails exhibit 1153 are not admissible. One I have placed before your option, that there is no certificate. There is no other way to prove these email as held in my own. Bashir's case as well as our two concept. But the second ground on which I will still urge that it is not admissible. The lordship will find that these which were ultimately printed out were in Manipuri language. Originally, these emails were in Manipuri language. And this was translated. Who translated it? We do not. Then PW 79 took it to an unknown professor of Bangalore, who is said to be versed in Maithili language. He authenticated it and issued a certificate according to them. I'll first take your lordship to the evidence of Surinder Singh Bakshi, his PW 79. And I thought we will get him at page, paper book 3, compilation 3. Compilation 3. This is the one, this one. 3. At page, paper, at page 84. Okay.
Yes.
I'll place it. Is a man from NIA at that point of time. I joined NIA on 23rd November 2009 as DSP NIA on deputation from PSS. I was interested in this case that it's also so. I remain as one of the IUs in this case till filing the charge. I repatriated to my parents' department also. During the course of investigation of this instant case, I assisted Sri Shyam Prakash Pani, IPS NIA, New Delhi, who was chief investigating officer in this case. I have carried out the pointers of investigations which were assigned to me by CIO in this case. This case relates to arrest of R.K. Meghal, chairman UNLF and other members retrieval of digital evidence in their disclosure during the course of investigation, which were translated from Manipuri, your lordship may mark it, which were translated from Manipuri language to English language. Who did it? He doesn't say. And were produced before this court as the evidence after due authentication by protected witness number 80, sorry. These transactions were of emails in Manipuri language and were exchanged by the members of UNLF, namely R.K. Meghal, self-styled UNLF chairman, on the email Enterprise PK, so and so and so and so. There is another ID of, so it was not required, Miller. Only thing your lordship will see that this was this was in Manipuri language. And it was translated. Who translated it is not there, but it was, it says it was authenticated by PWAT. He is a protected witness. The other things I'm not concerned with it. And this protected witness number 80 is not there in the, the regular, the paper book that has been given to us. And that's why we asked for it. And the charge sheet which is given by we have supplementary paper book. I just want to show his name. I mean, that he's a protected witness. You also can take up this supplementary. This was given after the lordship's order on 4.8.
Volume 1, this part 1,
Supplementary.
supplementary. Okay.
It was given only after the lordship's order. The charge sheet begins at 270. And you turn to page 307. Three zero seven, I'm showing it, just to show that list of enclosures are there. And then I'll place annexure E. Three zero six, a serial number 26, list of enclosure. We are concerned with the first annexure E, list of witnesses.
Yes.
The list of witnesses starts from page 310 and the relevant BW80, the lordship will see at page 317. 317.
Yes. Protected witness C.
See, statement not recorded. This, I want to show this. So it has, it is in the evidence of 79 that these emails were in Manipuri language. These emails were translated by whom, not known, but it was said to be authenticated by a protected witness. Witness number 80. Now, he was not produced, that your lordship has seen. Now, your lordship will kindly see the evidence which has been relied upon.
He was not examined in court.
80. Suspected with you will not get in the regular this thing. We applied and we got. Now, if I will show the certificate.
Yes.
Your lordship will see compilation 1, certificate that I don't know how it was, but it was exhibited.
Page,
Page 100.
yes,
Whomsoever it may concern. It is certified that the undersigned is working as assistant professor and is well versed with Methi language in Manipur. It is further certified that as per request of Sri Solicitor Senator, I have gone through the email in Methi language in Romanic script with its English translation version. The email and their translation versions, which have been furnished to me by Sri Surendra Singh Bakshi, he is 79, PW 79. Along with index of total 88 mails with corresponding attachments. After going through emails, I certified that the English translation of the emails are found correct and are the true translation of the corresponding emails in Methi language in Roman script. As a token of this correctness, I am issuing this certificate and handing over to Sri Surendra Singh Bakshi, Deputy Superintendent of Police, along with furnished documents. So it is not signed. It's an unsigned document. Your Lordship will see the cross-examination of this person, PW 79. And compilation 3. 79, and everything is made there.
page,
Page 86 of compilation 3. I place this his evidence at page 84. Just 4 lines I will place.
he's PW 79.
Surinder Singh Bakshi.
How many languages is prevailing in Manipur?
Tribals have their own language.
No, this Metai, Methi is one. That is the,
That's the main language.
that is the main language. Okay.
Page 86.
Yes.
Cross-examination. It is true that no mention was mentioned in Exhibit 185, here just to read the certificate, about the person who translated the emails from Methi language to English. I do not know who translated the said contents of the mail. It is also true that Exhibit 185, nothing was mentioned about the person who issued the certificate. There is also no signature or any particulars of the certifying person. This is empty. No, I will, just for an example, because they are using he's a protected witness. To close all his arguments, that he's a protected witness on that ground that he has not been produced or he has not signed. I'll place, well, I have to just show this, so I'm not in violation. Your Lordship can kindly take part one volume.
Part one. Of the compilation, paper book.
Kindly come to page 162.
Page
162.
162.
Kindly see the name of the witness.
Yes.
My name is Mr. X. In bracket, protected witness. He was produced. I'm not reading anything that doesn't concern.
No objection from X.
No,
Family Twitter.
he has a lot. So now your Lordship will see the next page, page 164. 164. I'm showing he was permitted to be cross-examined. 164, your Lordship will see the cross-examination. Then your Lordship will go to 166. 166. Mr. Y, here it is, Mr. Y. My name is Mr. Y. He was produced. And then he was permitted to be cross-examined, which your Lordship can see at page 168. But that witness who said to have authenticated and seen the translation, he was neither produced nor he has signed the certificate. Okay. And the two others were also protected, 3 and 4. That's why I have shown. They are expecting that from you. Now, my lord, the London Trial Court dealt with this objection of ours, which was taken. And my lord will find at page 51, paragraph 51, sorry, of the judgment, my lord, your lordship will have to take volume 1, paper book, part 1, volume 5. The judgment.
That you said on the last occasion, that he said that
Yes, sir.
this accused are from Manipur, they could have given objection. That is what.
Yes, yes,
Huh.
yes, that's what he said.
Yeah.
In that place. So now, my lord, these two grounds. One, email could not have been admitted in evidence because it was not supported by a certificate under 65G. Second, the copies allegedly, my lord, translated into English. Who translated it? Who authenticated it? All remains mystery.
Just give me that page where that is mentioned.
Paragraph 51, of the judgment at page 973, paper book 5, volume 5, part 1 of the judgment.
Volume 5.
Yes, part 1, volume 5, at
Page?
page 973, paragraph 51. Paragraph 51. And another one your lordship will, may note down. On the basis of these emails, on the basis of these emails, all the accused have been held to be member of the UNLF. Because for some, there is no oral evidence, only these emails. That is in paragraph 52. At page 974.
Just
Now,
tell us one more thing. This email, series of email is by one person or several persons?
we don't know who are those persons, but
No,
there
no,
are,
since-
yes, different persons.
They're different persons.
There are
Are,
different persons.
so
that we-
all of them who had sent mails or received mails are held to be members.
Yes. No. Those whose names are mentioned there also.
Okay, those whose
Yes.
names are mentioned in that correspondence,
Yes. Now,
email
suppose-
correspondence are held to be members.
No, it's Rakesh. Now, full name is not there. Father's name is not there. It's mentioned Rakesh. There is no verification, no investigation, whether this person is the same person. I'll place that. So only on that, contents of the email. We are not party to the email. It is neither sent by us nor received by us. There's not even an allegation of that. It is sent in, it is allegedly an exchange between X, Y, Z to 18 and 19. We don't know who are they. And
But somebody lost membership in the parliament just because of that. You see, this email has to be in, between two non-individuals. Recently, a parliamentarian, I forget the name always, had disclosed that password to somebody else from foreign origin, and then those emails, just because they had a password, it says that it was a parliamentary breach. So therefore, you see, if it's a mail between two persons and others
Yes.
have access to it, definitely there will be presumption.
access, if they prove that, yes, we have received that mail. Those things are, nothing is there.
It's not there.
No, I'll check those emails, few emails which have been stated to be the same. But before that, I go to those emails.
Because those IP addresses have to be identified. IP address, let us say it's one is of A, has to be identified.
They seized the laptop, both from 18 and 19, it's on record. From there, they never tried to take out anything. His IP address would have been there. If it was sent and received. They did not do anything with that. They have taken it out from the, allegedly from the computer of NIA, in NIA office. We don't know anything. Now, before I go to the exhibits, relevant exhibits, where, my lord, my name supposed to appear. My lord, I'll place one thing, which your lordship said on the first day in connection with some other case. My lord, emails are also like letters exchanged between two persons. Now, today I write an email to my learned friend saying that Mr. Das has done something. So that can only give an opportunity to the investigating officer to investigate whether Das has really done it. Otherwise, suppose I wrote, A writes to B, sends an email to B that C has killed D. So C will be thanked because he has killed, it is proved. And they had only now, I will give you example of Jain Hawala that case, it's the GC Supla. Your lordship will kindly have compilation 2. Such case. I mean, I cannot imagine if GC Supla case was not battle, what would have happened on these bases? Because not only VC Supla, even LK Advani was there, VC Supla was there are so many. This is, my lord, at page 103, 1998, 3 SCC 410. Here, my lord, the charges were freed. The High Court struck down. Then CBI came in appeal, that was dismissed. I have given only that. The lordship may kindly turn to page 105. (105). At page 105, just above Precipitum D, on the right side, just above. The High Court, however,
Page 105.
Fine. Precipitum D. Just one line. The High Court, however,
Yes.
the High Court, however, observed that the production and proof of document by themselves would not furnish evidence of truth of the contents. And that during investigation, CBI did not examine any witness or collect materials to prove the same. With above finding and observation, the High Court arrived at the following conclusion. This is by Delhi High Court. In the present case, there is no evidence against the petitioner except the diary, notebooks, and the loot sheets with regard to the alleged payment. The said evidence is of such a nature which cannot be converted into legal evidence against the petitioner in view of my above discussion. There is no evidence in the incident case with regard to monies which are alleged to have been received by Jain for the purpose of disbursement. There is no evidence with regard to disbursement of the amount. There is no evidence with regard to the facts proof prima facie that petitioner Shri L.K. Advani and Shri V.C. Supla accepted the alleged document as motive or alleged amount as a motive or reward for showing favor or disfavor to the any person, and that the favors and disfavors were shown in the discharge of their duties as a public servant as contemplated by Section 7 of the Prevention of Corruption Act. Thus, the court will have to presume all the above facts in absence of any evidence in connection therewith to frame charges against the petitioner. The lordship will kindly come to the next paragraph, 17, my lord, at page 106. Here, my lord, and I'm placing it because I'll have to, when I go to PW 59, there are also exhibit 91 and 92 are loot sheets. So since I have opened it, I'll just place it so that next time I'll just remind you. Paragraph 17, just above paragraph 17, your lordship will see section 34 of the evidence it is. and I'll place from there. Entries in books of accounts when the books of account regularly kept in the course of business are relevant whenever they are referred to a matter into which the court has to inquire, but statement shall not alone be sufficient evidence to charge accused persons with liability. From plain reading of the section, it is manifest that to make an entry relevant thereunder, it must be shown that it has been made in a book. That book is a book of account, and book of account has regularly been kept in course of business. From above section, it is also manifest that even if the above requirements are fulfilled and the entry becomes admissible as an evidence, still the statement made therein shall not alone be sufficient evidence to charge any person with liability. It is thus seen that while the first part of the section speaks of relevancy of entry as evidence, the second part speaks of in a negative way of its evidentiary value for charging a person with liability. It will therefore be necessary for us to first ascertain whether entries in the documents with which we are concerned fulfills the requirement of above section so as to be admissible in evidence. And if this question is answered in affirmative, then only its probative value needs to be assessed. 80. Books ordinarily means a collection of sheets of paper and other materials, blank, written or printed, fastened and bound together so as to form a material whole. Loose sheets or scrap of paper cannot be termed as book, for they can easily be detached and replaced. Then other decision is mentioned that we are not required to go into. The loose sheets cannot be termed as a book of account, and therefore will not be admissible in evidence because of the embargo contained under section 34 of the Evidence Act. Then the other thing, my lord, which is very important, whatever is mentioned in the books of account, and just prima facie, it has only prima facie value. It has to be investigated. I mean, as I said, A writes to B that C has committed murder or killed D. That will not be a proof against B. It will only give a source information that yes, such thing has happened. So you inquire into the matter. Find out, collect number one, first of all, you have to see whether he actually died. If he died, how he died, all sort of investigation has to be open to in order to fasten see with the liability of murder. Not because it is mentioned, so it is proved. Cannot be taken as a gospel truth. This is my submission. Now I take your lordship to the emails which have been relied upon. In fact, with your lordship, you will see only two mails are there in one sheet of paper. And we have annexed compilation one. My lord, compilation one, your lordship will take up. Our compilation. Page 77, my lord. Page 77. 77
77.
of compilation one. Now, these are translation errors. Your lordship will not find the date, time. And this is from some unknown person to Enterprise DK. I'm placing one, my lord, that is exhibit, my lord, if I can say 11551 maybe on the top, we don't know, like this. Yesterday, Khuma, Aro, Khaden were detained under NSA. Wangleng Thoiba was arrested formally. Wangleng in connection with different cases of Bisenpur Diri. Thoiba in connection with different case of so and so. Londani and Rakesh jumped bail. They are saying this is me. They could have found out in which case I was granted bail. And where is the order to show that I have jumped bail? I have jumped bail, there will be an order of cancellation of bail in the court. Simple thing, they could have done it in order to connect me with this. They're not done anything. Then the second one, your lordship will see. When we get a chance, we shall try to repeal NSA for 5 of them. If any possibility of, your lordship will see, possibility of Londoni and Rakesh to jump bail. Here they say already jumped bail, we don't know the time, nothing is there. So this, my lord, my request would be that your lordship will summon the original. You see. Original has not been exhibited. Original has not been exhibited.
This is exhibit 115.
115. In bracket, it is 51 and 52. There is one more at page 82 of the same volume. 82. This is again by some unknown person, I think 10%.
That will be easy to find out. This 115 was exhibited by which witness?
It was by 53.
By 53.
By 53.
EW 53.
Mm. 53 is page 59 at compilation 3. Compilation.
59.
The relevant 115 is at page 61. There's nothing. He just said this is my signature. At page 61, you will see all 115 says my signature, my signature.
No, so they are accepting this as an email, not the original one.
No.
So now you'll have to address us on this.
11551, you lordship will see at 63.
Print out of the email.
Okay. This is English translation.
The English translation has been.
Because if this is if the translation is a email, but then the original was never proved. So this becomes a secondary evidence. It's not a primary evidence at all.
The original should be there, Madhara. No.
No, no, we are reading the statement at page 63. It says exhibit 115 by first line, exhibit 115 by 51. That is at page 77 of that compilation. Compilation is 1. So it says 115 by 51 is my signature, which appears in email marked as E11 and 115 by 52. So you see here, page 77 is 115 by 51 is the signature, and eligible signature is 115 by 52. It's only that much.
The original is there. This is a translation or the, I don't
No,
know.
no, then the evidence, it should have been said, the original email is marked as 115 by 51. English translation is marked as 115 by 52 or something. So we'll have to address us.
That's it.
Hmm.
You're also seeing 82. Page 82 of the compilation 1.
Page 82, yes.
I'll take it. Yes, yesterday so and so, saying are booked under NSA. So and so are formally real estate. Wangling something. So far as that, Londani and Rakesh given bail. They are jumped bail, possibility of jump bail. Here they say jump given bail.
Yeah, you're referring to which page?
Page 82 of compilation 1.
Okay.
From where I committed 77. 115.
82 compilation 1.
Yes. Page 82.
Because definitely they will be, if their bail is granted, they will be granted in NSA.
I don't know whether because NSA it can only be payroll. There is no bail in NSA, preventive detention. There will only be payroll.
Oh,
But first of all, we don't know whether it is Rakesh, this Rakesh who is the friend before the lordship. Somebody should say, somebody should identify, or this is enough. Establish my identity. Not here. Court का नहीं. No. पढ़ लो बात.
page 82, you are showing us 115 by 705.
704 and 705.
That's not even there in page 320, sorry, 78, 79.
PW 53.
Yes.
That World War I, we have not checked, but I've asked you to check. It may not be there.
The last exhibit is 115 by 652 at page 79.
So that's why we wanted, the purpose of filing an application before the lordship was that everything should come here. Authenticated copy we get to see. In some of these type of email, what I been interpreted is detention of dossier was proved by district magistrate, NSA. Lordship will see preventive detention. The difference between preventive detention and punitive detention. Preventive detention is merely based on apprehension. And it is for the purpose that he's likely to do some act on, you have come to a conclusion before he does it, arrest him. Punitive detention is entirely different. It is said to be proved beyond reasonable doubt. Now, first time I have seen the NSA dossier has been proved in a trial, which is no evidence in the eyes of law. But district magistrate have been produced. All the NSA documents have been proved, have been exhibited before your lordship.
Antecedent.
What antecedent in this thing? Read 75. If it is second offense, third offense, it will lead to enhancement of sentence. So you cannot bring something which is mentioned as a gospel truth that a district magistrate mentions it and then it becomes proof. Read something sometime.
No, but there is a difference. If I have read correctly, I can't recollect where I have read it. But it says in this NIA, it's not a police, and therefore requirement of case diary is not there.
If NIA is not a police, it cannot register a case. Under 154 CRPC, kindly see. It has to be registered before a OC police station of a police. So unless that is there, it will not. It cannot investigate. And we'll check up.
NIA, but
You have
NIA,
said we'll check up. NIA is not a police, then once.
but it has power to investigate.
No,
It has the power to register and then do it.
then the 161 statement should be admitted. Then it is not made before the police. So
That I know, this is something which I'll have to clarify from you both. Because you see that the notion which I'm having, last time we had a discussion, because you see, so far as case diary is concerned, for case diary, I'm a bit acquainted about the procedure of its contents and the procedures and how much of that can be proved. But in this NIA matters, I have no clarity in that point.
In fact, I'll tell you, they just did that, what is his name? Mohit Vajay's case. And that, I think, argument went for so many weeks before the Chief Justice here. That a very ingenious method was adopted. 161 statement given by witness, when he turned hostile, the whole thing was placed in the before the IO. And IO was made to say, yes, he has made this statement, and the whole 161 statement was in inverted comma was taken, and that was taken as evidence.
No, that can only be for contradiction, but it won't become an evidence.
161 is made before the police. And if your lordship will see section 24, 25, hey, stricture your lordship will see that the stricture is now expunged. But then his lordship gave a stricture for this.
No, because what
Unheard of.
because what I understand is that, you see, even I have that view. If for purpose of contradiction, you want to place it, then the statement before 161 has to be recorded, and then he will say yes or no. But it is only limited to the purpose of contradiction. It doesn't become an evidence.
Absolutely correct. This is what the division bench held. And my learned friend had hard time. He still like it. That's a pretty good thing. So, my lord, anyway, that's not, I get you. My lord, this, let me just place one case. If it's there. Ardhan Saha. It is 1975, 3 SCC, it's 918.
Because for that, I always give an example. It's a common example. I repetitive example I give in my court. Self-declaration. X comes before the court and says that, well, I am the president of India. 3 of his friends also stand up and say, president of India. Then police records his statement. In that statement, 161 is the president of India. And then he comes and states that it has been proved and therefore, please give me that office.
What your lordship says, I remember a small couplet poem by one Gopal Singh. He narrated, my lord, what used to happen during monarchy. When the law was, there was a theory, your lordship must have read, the law is nothing but command of sovereign. So it's in Hindi, my lord, kindly excuse me, I'll just tell. Gopal Singh writes, Raja bola raat hai, रानी बोली रात है, मंत्री बोला रात है, संतरी बोला रात है, सब बोले रात है, ये सुबह सुबह की बात है. So, this is
Because you are servants of the king, not of the sun. Continue to. Mr. Das and Mr. Mishra, today we have some compulsions. And this division bench will break up at 3 o'clock. But then there's again a single bench. And then we have to rise early today.
I know. Now, I think 90% is over. At least this I want to finish within 1 hour.
Because I have to take 2 minutes rest. And thereafter, I'll be taking a second appeal in single bench. So jumping from CRP to CPC, I need to
You
change over.
remember the additional journalists, one word, how many days we argued before Justice Navlekar and Justice Ansari?
Yes,
And
it took entire day.
I think more than 2 days we argued. All those English decisions I cited.
Yes,
And good thing was that what we said, of course. you
was accepted.
At that time worked very hard. It was very accepted.
No, that gave an experience of 2 things. Number one, I would still remember, I'm sharing, Mr. Das, there was an experience in the hearing in the High Court.
Yeah.
I was, in fact, nobody then. And then seniors like Ms. Mishra and others, I'm not naming them, there are 5 seniors in above me. And there was a small issue with regard to booking of interest as expenditure, whether it be a capital or revenue expenditure. And I was trying to explain to seniors, and then with their blessings, they said that, okay, you argue the matter tomorrow. It was a division bench. And to argue that point, a very learned and renowned lawyer of the country at that point of time was there. I'm not naming them. And the division bench had to ask Mr. Mishra and the seniors, is the sitting arrangement correct? Because I was there. And their greatness was that they took the next seat. And that is an experience, and that is judicium generis. It took 2 days of hearing it before a division bench to understand the meaning. That is one part. Second part is that the seniors directed us to find a judgment. And we found a judgment after 3 days of spending time in library.
Very hard. All of
In the library, 3 days of research and one judgment of Privy Council. And seniors saw this, okay. The next day we came for argument, and 2 of us who were the youngest in the ladder, we were a bit offended. Nobody appreciated this hard work. Nobody saw this. No, not that. Now you see, those days we couldn't understand, the age. They did not say anything, and the next day when this argument started, it was this judgment which they took the entire day of hearing. 2-page judgment took first half, Mr. Mishra, entire first half on that judgment. And then we could understand their depth of hard work done, their depth of study which they did just like by throwing this paper here.
all those things catapult you where you are today.
Yes, yes.
I will say that.
Yes,
Nothing more
definitely,
good.
definitely.
That is
For that, I'm very grateful because I couldn't shake off those feelings even after 15 years now. 15 years?
it will be, yeah, 2002,
2002.
2002, 2003, now Rekha was then. It's justice.
2002, 20 years now. I've not been able to forget any, what do you call, any part of that endeavor. Huh?
Part of life.
Huh?
This was originally, we remember 2 cases. One is this, and the other was in Sukhia Trading and all of some.
Yes.
That, where we were there, that Solicitor General, Additional Solicitor had to camp here. It was such a contested case. 1 week he was here. And the bench was presided over by Justice Chalmeshwar, and again, I think this is Amitav Rao. Both were there. Anyway, my lord, all day, that's one. So now, my lord, I have placed the one part of the evidence, that is emails. I have made my submission. Now, the other part of the evidence will be these 3 witnesses, PWs, which I'll place. All these 3 witnesses, my lords will find in compilation 3.
I was just noticing one thing. This PW5, page 34.
Yeah.
I mean, continuation of where we ended on that day. Sorry, in the first hour. Here they have exhibited this, the hard disk. And here what they have also done is that they have exhibited the original, what you call emails, as it appears from here.
I'll make it, when I come to 24, accused number 24, that time I will say about the hard disk. How this
Okay.
hard disk, it's in the evidence. What they did was, they have transferred from that computer to a hard disk.
Okay, so it becomes a
And
secondary
that-
evidence.
And that was sent to CFSL Chandigarh.
Oh, so it was transferred.
Yes,
It becomes a
because-
secondary, it becomes a secondary evidence.
And secondary or secondary, and CFSL, they gave them the soft copy and as well as the hard copy with their signature and seal.
Okay,
So that has been relied upon for accused number 24. And that by no stretch can be said to be admissible. That I will show when I go to 834.
Okay, I was thinking this was the mail related to this 18. No,
No, 18 is yes, only this. 18, but then what they did, it's in the recovery memo, if you will see, of 18.
no, means what I'm saying is that my question is that this exhibit 115
Yes.
is not referable to PW5. No,
PW 50, PW 53.
no. In PW 53, he gives two numbers
Yes.
of exhibits, 115 and one more. There are two numbers, E something.
That is, those are documents. E, document number.
Acha.
Those are document number.
Okay, so it is not relatable to this PW5's evidence, where he gives the original documents email server. It's not connected. Okay. No, it's okay. Don't bother. If that is correct, because I was under the impression that,
Those are documents.
okay.
Now I come to PW, the evidence against the appellant, accused number 6. So there are, as I said, 5 witnesses, but 61 and 63, the court has not discussed. I'm not going. They are servant of PW, 13. I'll first place my lord, PW 9, who is L. Premchand. PW 9, who is L. Premchand. Compilation 3. Page 41. of
Compilation?
3. L. Premchand. PW 41. This fellow is a professor is a director in educational multimedia, Manipur University. Accused number 6 was a student leader. Now I'll place his. At present, I'm Director, Educational Multimedia Center, Manipur University. In 2009, I had a very uncomfortable journey to Kathmandu. In fact, I was supposed to come only to Guwahati and meet teachers of Anthropology Department, Guwahati University, and Anthropology Department of Cotton College. By that time, our department was assigned to produce e-contact program, content program on anthropology by UGC. For this matter, one Arun Kumar, he is PW 17, Dr. Arun Kumar, Associate Professor in the Department of Anthropology, Manipur University, was officially engaged as course coordinator. His function was to bring in a good number of teachers from university and colleges across the country, because this was a national mission project. And in fact, he completed 5 models of e-contents of pilot project. After that, he suggested me that we go to Guwahati University Anthropology Department and Cotton College teachers and talk to them to please be a part of the project as resource person, as resources should have been. I thought this was a good idea. And accordingly, I requested our university authority to please allow and visit Anthropology Department, Guwahati University. Our university authority graciously agreed to our proposal and gave us permission, gave us official leave for 4 days from 14 to 17 September 2009. But in the meantime, my course coordinator and another person, S. Rakesh Singh, is talking of Appelant, proposed that we can extend our journey for 1 day to Kathmandu, and that they will bear our journey expense. But I'm pausing here for a second. The I'll have to come back. Your Lordship will kindly note, he says, my course coordinator and another person, Raki, approached him and said the journey can be extended to Kathmandu and that they will bear. Now, while recording, the learned trial court has recorded that Rakesh Kumar approached and said he will pay the expenses. So there is misreading and perverse finding that I will show you, Lordship, just mark it and I will show you. Because here it is, they will bear the expenses and course coordinator has also done. I agree to their proposal because going to Kathmandu was something like dream come true. But again, later on, after some days, they reveal, your Lordship will mark it, they reveal that we are going there to meet chairman of United National Liberation Front because the chairman wanted our view on cultural aspect of Manipur. I strongly disagreed and felt that there was design behind the whole scheme of things. And I refused again and again, but they kept insisting and told that it was a matter of 1 day. Finally, I had to succumb to their insistent pressure, which amounted to a serious level. I amounted to a serious level. But I insisted that it should be for 1 day because I had my preoccupation to do at Guwahati. So I was taken to Kathmandu. At first, on arrival at Kathmandu, I was taken to a hotel there. Then after a few hours, I was taken to a house there and we met Meghana and few others. There were talks on many issues, but I myself confined to my specialized subject of culture and performance of tradition of Manipur because I have published books and articles. I myself, a theatre director known in Manipur in many parts of the country. My play had been shown in many parts of the country. I believe because of my exposure in the area of art and culture, the chairman wanted to listen some of my views. I never said anything, kindly note my note, unconstitutional and anti-national. As far as I remember, my views were rational and academic. But it was differently charged situation because the chairman and a few more people whom I never met in my life, kindly mark it. I can tell my lord, this person, he has admitted in his cross-examination that he belongs to same village as accused number 9, who is referred as chairman, and knows him since childhood. He's from his village. And your lordship will see what he's trying to project, whom I never met in my life. So whenever I spoke in any way, I never annoy them or make them unhappy. So I was I was in a differently charged situation. I initially thought, as they told me, that it was only for a day, but I was compelled to stay perhaps for 3 days, thereby bungling all my official works to do at Guwahati. I could not find any ways and means to come out. I skipped most of the time during the meeting and went for shopping. I bought books and some sleepers for my children. I never came out. I have to bear help. After 3 days of confinement, I came back home and few days later, I came all alone to Guwahati where I met teacher of Guwahati, Cotton College, and requested them to please join project as a resource person. My lord, he has done shopping. He has done shopping for his children. Then he says after 3 days of confinement. And I'll tell my lord why, how this has happened. Because unfortunately, these things should have been in cross-examination, but it is not there. And very further. I completely disengaged.
At least maybe my wife would love this confinement. At a shopping mall.
Where you are allowed to
At a shopping mall.
disengage Mr. Arun Kumar as a course coordinator because of his bad experience. Instead, I engaged 4 or 5 other teachers. So he suspended Arun Kumar from within Manipur as a course coordinator. So so that I may complete production of e-contents of program for entire undergraduate course of anthropology. Teacher from Rajiv Gandhi University, Itanagar, so and so, and they're not very relevant. I engaged Mr. So and so, so that I could complete my project within a stipulated time. Next para. I do not know anything about Lampak. This interface was something like a study circle, platform for intellectual exercise open to all. There was Talka, given to many experts in many fields, human intelligence. So it's like seminars.
Talks, it should be talks, TLKS.
Where talks given by many experts in many fields, like human intelligence, emotional intelligence, it talks on cultural aspect, historical aspect. It's like seminar participated by 40 to 5 people, or I don't know. Exhibit 535 is the photograph taken at Kathmandu during my visit in the year 2009. Exhibit 35-1 is my photograph. Exhibit 35-2 is photograph of Rakesh Singh. Exhibit 35-3 is photograph of Dr. Arun Kumar. Similarly, Exhibit 36 is another photograph taken at Kathmandu. Exhibit 31 is my photograph. 36-2 photograph of Rakesh Singh. Exhibit 33 photograph of Arun Kumar. Today I have seen Meghan in the court. I say I have never met him in Kathmandu. I say that I have met in Kathmandu. Cross for the accused. I duly intimated about my visit to Kathmandu to the concerned authorities of Manipur University. This witness again says he did not inform about his visit to Kathmandu to Manipur University authority. I deny the suggestion that I did not visit Kathmandu. I did not meet Meghan Kathmandu any time. I deny the suggestion that there was no occasion of confining me in Kathmandu by anybody. I also deny the suggestion that Exhibit 35 is not the photograph taken at Kathmandu, and the said photograph is fabricated. It is true, Your Excellency, it is true that R.K. Meghan is a resident of my village, and I know him since my childhood. Then, my lord, Your Lordship will kindly come to Dr. Arun Kumar. And after placing Dr. Arun Kumar, I will say, my lord, what it appears from the inference will be from whatever is recorded at the court. At page 46 is Dr. M.C. I completed my MSc in anthropology from Ranchi University in the year 1984. Thereafter, I did my PhD in anthropology from Manipur University in 1991. I joined Manipur University as part-time lecturer in 86. I am still working in Manipur University now as a professor. I have 3 brothers, and I am eldest. The second one, named Jayanta Kumar, joined UNLF in 1982. And till today, we don't know, we do not have any touch with him. We have 3 sisters. The youngest one, Londhini Devi, who eloped one Jiten, who is member of UNLF, and she eloped, we have biked, as she has eloped, we have boycotted her. My lord, Londhini Devi, I don't know if I'm correct, I'm not appearing for her. One Londhini Devi is accused number 14 in this. Accused number 14. And her husband, Jiten Singh, is accused number 10. Here in this case. In 2007, there
And this
was
Londoni Devi is
accused
accused
number 14.
14.
One Jiten Singh, I don't know whether they are same person. One Jiten Singh is accused number 10. 10, he is appellant. Yes, right? That we did not have. His appeal is also before Russia. Both, Londhini Devi, and if they are the same person, the council will be able to say. My lord, item number 19 is Londhini Devi. Oh, your lordship says it is today. And item number 30 If he's the same person, he's Jitan Singh, but there are so many. I'll please call them in. In 2007, there was a web advertisement regarding one seminar on youth and social problems, which would be organized by Doll Foundation London. As I did not have any sponsorship for attending the program, I talked to one Rakesh Singh. Who is known to me since his childhood, as he is son of one of my teacher, and he was student of Manipur University also. I told him that he told me that sometime UNLF is sponsored for academic purpose. He told me to write a letter to Chairman UNLF. Thereafter, I wrote a letter and handed over to Rakesh, but I do not get any reply from UNLF. This is one part. In the year 2009, I was to go to Kunming, China, to attend International Anthropology Seminar as a part of Indian delegation in the month of July 2009. Rakesh told me that he would be in Bangkok on the 1st of August 2009, and I could join him in Bangkok. I joined Rakesh at First Hotel in Bangkok. On 2nd August 2009, he told me that Chairman UNLF Meghan may meet us. As I was writing a book on conflict resolution in Manipur, I was surprised as well as delighted to meet R.K. Meghan. At that point of time, it was only UNLF that talked about conflict resolution. So the next day, R.K. Meghan came to the hotel and we met and talked with him for about 1 hour on various social issues of Manipur. I and Rakesh stayed in Bangkok for 4-5 days. I returned on 8th of August 2009. In the month of September 2009, one Premchand, he is 9, one Premchand, director of Electro Multimedia Research Center, and I were to go to Guwahati to meet teachers of anthropology. Rakesh came to know about this and told me that our journey could be extended up to Kathmandu. There we would meet some leaders of UNLF. In Kathmandu, we stayed in one hotel. Next morning, one boy came to our hotel and said their leader liked to meet us. He took us to a hotel in the outskirts of Kathmandu. There we met R.K. Meghan, so and so and so and so. We discussed various social issues and cultural program of Manipur. We came back to Manipur after 1 day. Then, my lord, the next line that I will read will show, and from there I'm making an inference. He said, next line, my lord, in February 2010 again, I and Premchand went to Kathmandu as asked by UNLF and reached Kathmandu. There was a brief discussion with R.K. Meghan, so and so, about unification of Manipur insurgent activities of MPA, revival of Manipur religion, etc. It was a general discussion. I opined that anti-Hinduism campaign should not be encouraged by insurgent groups. I also told them that the entire insurgent problem should be re-evaluated in the tuning change of environment. I came back after 1 day to Imphal. My expenses to China was borne by the university and my stay in Bangkok was by UNLF. I also, my trip to Kathmandu was borne by UNLF. I will be able to recognize R.K. Meghan above. I heard Jitan is in jail and Lodhini is on bail. Now, my lord, it appears that apart from Rakesh, these two witnesses, PW9 and 17, they used to meet Meghan. The Meghan was from the village of PW9. He knows him from childhood. PW17, my lord, if accused number 14 and 10 are really there, his sister and brother-in-law, and his one brother was already, according to him, in Ulfa, in UNLF, then he was also known. And they were working on conflict resolution, they were writing this. In that connection, they may be meeting me. accused number 19. And when this was known, became known to them, PW19, then they may not, I mean, it's not in the cross-examination, I'm saying repeatedly, suggestion should have been made. But once they came to know, they brought them in to implicate accused number 6. So they're not saying anything. They say that he said, good, let's go to Kathmandu, we'll meet Megan. After that, he had no role. But from there, it was inferred that Rakesh is a member. So they don't say anything. So this is an inference from here. There is no evidence that he is a member. They are inferring that CCI has told this. And they are the person who have gone and met on their own. And they say that nothing, we discuss only, on both occasions, we discuss the social issue. On that, if Rakesh can be held guilty as a member, they should also, they are also, but it's not possible. There has to be some real hard evidence to show that he was a member. On inference, no. This is my humble submission because the consequences are grave. Now I'll place cross-examination. And another thing I want to point out, my lord. Say that Rakesh came to know and he says, I'll be in Bangkok on so-and-so date, kindly meet me. Passport is exhibited by Rakesh, is exhibited by PW69. They have not shown, it's just one page they have exhibited. They should have said, yes, at Kathmandu no visa, but Bangkok visa is required. So here is the visa and these are the dates. At least some sort of corroboration would have been there. That is not there. Now I'll place my the cross-examination. It is not a fact that Rakesh never told me that sometimes UNLF is sponsored for academic purpose, and he also never told me that to write a letter to Chairman UNLF, it's not a fact. I never wrote a letter to and handed over to Rakesh. It is not a fact that in year 2009, I never met Chairman of UNLF, Mr. Megan at Bangkok. It is not a fact that I never stayed with Mr. Rakesh in the first hotel of Bangkok, so and so. It is not a fact that I never discussed with Mr. Megan regarding conflict resolution, Manipur in Bangkok. It is not a fact that in the month of September 2009, I never went to Kathmandu with Mr. Premchand and Rakesh Singh. I never met UNLF. I never discussed any matter relating to about the unification of Manipur insurgent activities of NPA, revival of Manipur religion, etc. I also deny the fact that I never discussed any regarding various social issues and cultural program of Manipur. Then when he says, it is true that I have no idea whether Rakesh is a member of UNLF or not. So far I know Rakesh has not committed any illegal act or activities which is against the Union of India. This is from his knowledge. He's saying it's not an opinion. It's a knowledge. From knowledge he's saying I don't know. Then, my lord, these are the two witnesses. They are star witnesses, my lord. Now, my lord, I'll just point out the contradictions that the perverse recording of these witnesses by one of this, the passport is concerned, we have not, there is only one page, and this is part 2, volume 3. Exhibit 133.
It's okay, we take your word for it.
Here and thank you. Now, my lord. Oh, judgment. My lord, at page 189, what PW9 has stated, I have just taken your lordship. Then, sorry, I'll give the page number. page 41 below. Compilation three.
Comparison 3, 41.
My lord, at page 42, I have said at that point of time, the lordship of conjunction. At page 42,
Yes,
10th line, well, towards the middle, 10th line from the bottom.
yes.
But in the meantime, lordship of- but in the meantime, my course coordinator and another person, one Rakesh Singh, proposed that we can extend our journey for 1 day to Kathmandu and that they will bear our journey expenses. I agreed to the proposal because going to Kathmandu was something like dream coming true. But again, later on, after some time, they revealed that we are going there to meet Chairman UNLF. Now, what the learned trial court has recorded, that my lord will come to, paragraph 70, page 984. This is part 1, volume 5, judgment.
Part 1, volume 5. Yes. Page,
Paragraph, page 783. Oh, 983, I'm sorry. The relevant will be 984. Third line. 984, third line.
this page 42 was PW 17.
PW 9 below. PW 9. PW 9 below. Starts at page 41.
Paragraph.
Paragraph 70, 70. 70 starts at 983. The relevant will be at 984. 3 lines. He further deposed. First line. He further deposed that S. Rakesh Singh, accused number 6, proposed that journey be extended to Kathmandu for 1 day and the journey expenses would be borne by him. So he says his course coordinator and another one person proposed that journey could be extended and that they will bear the expense. But here everything is attributed to accused number 6, as if he has said and he will bear the expense. This was, I can still take 10 minutes. I'll finish. Hello. Now, Lord, I'll place PW 39. PW 39. Well, compilation number 3 at page 49.
Page number?
Well, page number 49. I'm a graduate. He is my lord, N.G. Robert Singh. I'm a graduate. After my graduation, I joined my father's construction business at Imphal. My father was a special class contractor doing contract at PWD Government of Manipur. In 2004, we formed a firm by the name of Lupkist Nirman. His partnership firm with its office at Manipur and Delhi. We had two important works like construction of food park at Imphal and taxiway at Imphal Airport and construction of high-tech godown at Gazipur, Delhi. Our business expanded and developed, and there were lots of targets from underground organizations. We faced extortion from underground organizations, including UNLF. The elder brother, namely N.G. Rana Singh, was kidnapped by PPAC in 2001. We received telephone calls from some person identified to be PPAC, and they demanded 25 lakh for release of my brother. Ultimately, we paid that amount out to release my brother. The underground organization used to threaten us by throwing hand grenades, firing at our house, thus threatening to obey their demand. We are liable to pay underground organizations like UNLF, PPAC, KCB, PLA, KYKA, and so on. Whenever there was a demand from them, roughly we paid 30 to 40 lakhs a year to the underground organization. Now this admission of his before NIA made him a victim. He was forced to give certain statement to his own detriment. That I will show how. I know one Rakesh Singh who is my childhood friend. In the year 2008, Rakesh Singh approached me for sublet construction work. The term was that he will invest some money in work and he will get the bills along with profit in the construction work of food park project in the year 2008. Rakesh Singh invested 60 lakhs in 2009. He invested 40 lakhs in taxiway for supply of material and another 10 lakh in October 2009 in taxiway project. This way, if your lordship calculate, it comes to 1.10 crores investment in a firm which is an assessee to income tax. Robert Singh is not a tribal. And these are all cash amounts, as it will appear later. Rakesh Singh used to stay in Manipur. In 2008, he was advisor to student organization called AMSU and NEMSO. For this work, he used to frequently visit entire Northeast. I, along with Rakesh and many others, went to visit Vietnam to attend Northeast India Summit. This was sponsored by my Lord central government, and Rakesh was also a delegate. We will come later. Sometime in 2009, I came to know that Rakesh was arrested by police in Guwahati. There was balance bill of 17 lakhs to be paid to Rakesh. This amount was seized by NIA from me. Exhibit 87 is a cash production memo where on 8/8/2011, I have produced 17 lakhs for the officer. 87 are my signature. On 18/8/2011, I have received an order regarding seizure of 17 lakhs where I have been apprised that under section 25(6) of UAP Act, I have a right to appeal against the seizure. This money allegedly belongs to Rakesh, which has been ordered to be kept with the NIA and let for confiscation purpose. There is a provision in under the UAP Act, and an appeal is provided from that order. If it is Rakesh's money, why PW9 was informed that you have a right? Because he says it is Rakesh's money. Later on in cross-examination, he says, if these actions are nullified, Your Lordship will see. Exhibit 88 is the said order. Exhibit 89, I have produced certain documents before NIA officer which were seized from me. Exhibit 89 is my signature. Exhibit 90 is signature memo. I have produced certain documents before NIA officer which was seized from me. Exhibit 90 is my signature. After his arrest, I do not have any relation with Rakesh. Our firm has maintained Our firm has maintained a Kacha cash book for payment made to Rakesh. It's a proper partnership firm with office in Manipur and Delhi. He is maintaining Kacha. Lordship knows audited balance sheet will have to have all the details of money received, money paid. Nobody can say that, no, he gave me 60 lakhs and I returned him 50 lakhs. It has to be audited. Otherwise, the statement cannot be believed. And he himself says, I go to the process. Exhibit 91 is a Kacha cash book maintained in the hands of my account.
What is the provision? 279 SS.
Yes.
Income Tax Act?
Yes.
279 SS. Where money more than 20,000 has to be paid.
Yes. It has to be by account, by check or account transfer. Plus, he has paid 17 lakhs on behalf of Rakesh. Can he make payment without deducting TDS? Section 190 of Income Tax Act will come in. I have next slide with my compilation.
No, for seizure at least you don't have to deduct TDS.
No, not for seizure. He says this is paid to Rakesh. The money.
Money was payable to Rakesh but paid to Nia.
Yes. But
So
can I'm asking even for seizure, for the purpose of and how seizure was made is very interesting. He was forced to withdraw 17 lakhs from his account. and bring cash and give it to NIA SP, saying that this belongs to us, because this was dictated. It is not that Rakesh said there was accounting proper and then this was the balance money out of 1 crore. That he must have returned, only 17 lakh was there, invested 1 crore, 10 lakhs. Out of which 17 lakh was balance, where is the other? Where is the balance sheet? There has to be something, no? So therefore, you say that, all right, this 17 lakhs Rakesh has to get from me, I can take out from my account after deducting TDS, and the balance money I'll give it to you. That is his. Otherwise, he cannot absolve. Because he's appropriating, my lord, his profit from where God knows. He himself said, let me produce placement. I think I'll not be able to finish because I forgot the section 18 and section 121. That also will take at least half an hour. I'll not be able to finish.
121 IPC,
121A,
IPC,
IPC, and section 18 of UAP.
UAP,
There also your option say, 121A is conspiracy.
conspiracy.
To I think, wage war against the state. Under 120, he says there was no meeting of mind, there was no conspiracy. And then he has also given, the judgment is there unless there is a meeting of mind, and there is no proof that there is conspiracy. And with the same breath he held, 121, we are punishable without discussion of the evidence, nothing. Similarly, 18 also he says, 18 is also conspiracy, abet, incite, commission of a terrorist act. It is irrespectively whether it was committed or not. I mean, that particular act was committed or not. But Nalini, which I'll place before your lordship, says that for 18, which was similar to subsection 3 of TADA, there has to be a terrorist act. You cannot, in vacuum, you can say that, yes, there was conspiracy to commit a terrorist act. So then let me continue tomorrow with the cross. Hopefully tomorrow I'll complete all. Or if you lordship so pleases, if there is time, I can.
I'll just check up. Let's see.
Against.
For recovery.
Now I will let convey you that.
Mr. Das and Mr. RKD Chaudhary, will you say tomorrow then? The submissions of Mr. D.K. Mishra, Senior Counsel, assisted by Mr. B. Prasad, Learned Counsel for the appellant, in Criminal Appeal 262 of 2016, Criminal Appeal number 263 of 2016, 264 2016, 265 2016, and 291 of 2016 remains inconclusive. Mr. D.K. Das, Senior Counsel for the NIA, is a Senior Counsel assisted by Miss. Her name? Your name? D.K. Darji. Learned Counsel for NIA, and Mr. RKD Chaudhary, Learned DSGI, appearing for the Union of India are present. Next paragraph. List this on 6/2/2025 as part of matter.
So far 15 is concerned, he is only convicted under 20 and there is no oral evidence. 11, 10 and 11 have been convicted only on the basis of 8 and 11. No oral evidence. 124 sometimes.
Okay, because this dictation remains incomplete on that day also. Notes.
That I have filed a written argument. The only thing is, on the point number 3, which I took long time. There, I thought I will file after his reply. So I've given a very brief thing. Only that, if you lordship desire, I will place it. Otherwise, everything.
No, no, because you see, otherwise I'll forget my notes.
No, no, I have already.
Irrespective-
I have submitted written
No,
argument.
no, irrespective of your written argument, because if I rely on that, then means
Then I
my
understand.
bad habit is that only when I see my handwriting, I recapitulate.
My note, I cannot.
So that is the difficult part. Even if I can't read my handwriting, but I should see my handwriting. Huh?
Like doctor.
Like doctors, worse than doctors.
Now, of course, we can another item in there.
No, all those will be as leftovers.
I just pointed it out.
No, because
I
since
know.
we are continuing with 3 days in this matter, I thought it continue it.
No
This
point
is-
taking.
But this is voluminous. If I
Yes.
close it, we'll forget some track. Can we take up some other day? You want?
I also care to be run senior friend as well.
Okay. Just suggest when. We'll take it up next week. This the last matter is will continue, I think, for 2 or 3 days. The division bench matter. So next week is better. Suggest a date.
13th melody.
13 February. Okay. Both sides are duly represented. Or the joint prayer made by both sides. List as a parted matter on 13/2/2024. Yes.
Item 2 for orders.
It was sent on 4/1. It was sent to Lavazima.
Yes.
This service is not complete. The ID card is not returned. Mr. Agarwal will send it for Lavazima. The ID card is not returned.
I want to dispose of the small matter also.
No, you see, notice without service, we can't dispose it off. Can we do it?
You should come here, earlier paid the amount also.
Pardon me?
Earlier the main award has been complied with. It is for only this is future prospects also. And they said not you can dispose
Any
of-
lordship, talk about future prospect now. The judgment isn't passed. Now he's not mentioned anything about future prospect here. And he's saying that future prospect should be considered.
No, I have not applied my mind. What has happened? You are praying for future prospects.
Modification of in the order that 26/2018, passed in MSC appeal number 103/2016. So he wanted some monetary amounts to be apportioned. That's what I could follow. I others Could not understand the objective of this petition. What is petition is mentioned?
Yes, what is the prayer here?
If somebody has deposited 20 lakhs, no register of this also. Yeah, ISC bill number 160662. And the amount has also been dispatched to us.
We deposit the entire amount.
Yes.
Then what is your?
No, this MSCT appeal is disposed of.
Yes, yes.
If they have deposited money, then you don't need an order of the court. The registry will give it to you. Why this prayer for before the court?
They have deposited close to 15,62,394.
20 lakhs prior to that was deposited. You have yourself said in your petition. Look at your petition. Read your petition.
No, the award is scaled down to rupees 27,2158.
And the entire amount has been meant to you.
20 lakhs was deposited in 2016 and remaining 15 lakhs 27 plus interest was deposited in 14 to 2019 as per his petition. I don't know why he is coming to the court.
15 lakhs, 6 months.
So if you withdrawn it, just tell it to the registry. They will do that calculation and give it to you.
The claimant is suffering losses in his settlement. So we pray for release of the amount.
No. Something is wrong here. Because this, you see,
Pair number 13 losses, page number 14.
no. You see what we did was, no, you see, we did that calculation because you said that 20 lakh was deposited. So we said that while withdrawing, we converted few into the fixed deposits. You said that 20 lakh has already been withdrawn.
Judgment order.
Prayer actually is that 20 lakhs has been deposited and the balance amount deposited by opposite party bond may be allowed to be withdrawn. That is
already withdrawn.
only implied notes.
So this is clerical mistake.
No, but you see, there is no note saying that you have withdrawn that for 20 lakh rupees. In the MSCT appeal, there nowhere the office note does not say that you have withdrawn that 20 lakh rupees.
You have said.
Even that 20 lakhs have been disbursed in the following manner. Registered Honorable High Court disbursed the amount in the following manner.
So now he's saying that before that, this amount has been withdrawn.
Yes.
But what is the date? You have not given those dates. When you have withdrawn it?
13/6/16.
13,
6/16.
13, 6, 15.
16 law.
Where is it stated that?
Pair number 6. Page
Para number?
7 Lordship. Here's the check number 3699602,
Just a moment. Which page?
page 9.
6 and 7 law. Page 8, 9 law. अपनी दस पुलिस अपनी दस Where number 8 notes it is mentioned that at 24/6/16 it has been withdrawn. Now the balance amount has to be paid.
You just check this one, Mr. Goswami. Check this on note sheet. I don't think any order is required. You'll have to go to the registry and get it.
They have deposited, they have also said that this has been deposited on 14/2/2019. Entire amount has been deposited. You see,
But in Lordship, the entire amount is fixed deposit.
No, 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 no. Then you don't know the facts.
That Lordship,
This is something I will dislike.
Lordship, this is page
No, no,
number-
no. You see, when you made a submission, I have shown it to Mr. Goswami. Please look at that document. The 10 lakh rupees reduced in fixed deposit. 10 lakh rupees was returned to you. So balance amount, you go to the registry and take it. Now you'll have to find out if the balance amount has been deposited. Mr. Goswami?
the balance has been deposited. It is deposited on, there is a date also, no, so it is deposited on 14/2/2019.
14 to 2019.
19.
But there is no note of 14 to 2019. It's not there. Let the office do the needful. Both sides are represented. Sorry, no, the counsel for the applicant and just give me Mr. A.R. Agarwal, counsel for the applicant, and Mr. R. Goswami, learned counsel for the respondent number 1 are present. Next, the learned counsel for the opposite party number 1 has submitted that some of these 20 lakh had already been deposited before the registry of the court. Just pass that slip. Court.
The last order was on 16. Day after
Deposited, for which he is referred to a note contained a note of the Registrar General, which is appended to the record of IA 1606 of 2016, indicating that a account pay check for a sum of rupees 10,000 was issued in the name of Mrs. Nina Mili Pegu And that sum of rupees 5 lakh each in by way of 2 fixed deposit was also made for made in favor of the claimants. Full stop. Next para, the learned counsel for the opposite party number 1 has further submitted that the balance awarded sum has been deposited by the opposite party number 1 to the registry of the court on when? Mr. Goswami, which date? Mr. Goswami, which date? Which date you deposited?
Deposit it was on 14 to 2019.
14 to 2019.
Check number 476896.
White check number
476896.
896. Full stop. Accordingly, the accordingly, as withdrawal of money does not require any judicial order of the court. Just say, therefore, the office shall put up a note with regard to the amount available to be released to the applicants. Full stop. List on. 21 to 2024. We'll ask them to do the arithmetic. The office will do it. How much is left, how much is not. Pardon me?
Yes. Yes, disposed of.
No. We don't know where that money is deposited, where it is lying. Because I'm not passing vague orders which can't be implemented. You should have given a date. Please be vigilant when you are in court. I've given a date and you are asking again for a date. Mr. Agarwal, something wrong. Please be vigilant. You were busy talking when I was dictating the order. Don't do it. If you have to speak to him, you can do it outside the court, not when I'm dictating the court and then annoying me, asking that give a date.